Welcome, council. Welcome back to the 95th District Court.
Judge, you're chopping up real bad. It's real robotic.
That's interesting because I'm directly wired in.
Now you're better.
All right. Well,
You just had to say something, apparently.
all right. Council, welcome back to the 95th District Court. This is DC 19-18357, Adams Kebab and Grills Incorporated versus Sabre Realty Management Incorporated, Northwood Hills Village Shopping Center Joint Venture Limited. May I have counsel for the parties identify themselves, starting with counsel for plaintiff?
Cal Hamida for Adams Kebab, Your Honor.
Welcome, Mr. Hamida. Ms. Batiste?
Allison Batiste for Sabre, and thank you for welcoming us back, Judge.
You are most welcome. Thank you. And Mr. Zoyes?
James Zoyes on behalf of Northwood Hills Village Shopping Center Joint Venture Limited, Your Honor.
And are you, once again, just an observer today?
I am, Your Honor.
Very good. Before we get too deep into this, I have to once again remind you that this hearing, although it is being conducted remotely, is subject to the open courts provisions of the state of Texas Constitution. The doors to the courtroom happen to be open. The public is welcome into the courtroom. I am conducting this proceeding from the bench. There is no member of the public present. That's no surprise, but I'm putting that on the record that the courtroom is open. Also, we are broadcasting this on the court's YouTube live stream. That creates certain issues. Mostly that some people are tempted to try to make a record off of it by recording or downloading the file. That is expressly prohibited unless this court has authorized by order the remote recording of this proceeding. The court has not done so. There is one record and one record only that comes out of this proceeding, and that is the record maintained by the official court reporter for the 95th District Court, Ms. Rouse. Any questions about that?
No, Your Honor.
Your Honor.
All right, Ms. Batiste, I've got your, are we just here on, once again, the, what is now the amended second motion for protection?
Yes, Your Honor.
Ms. Batiste, once again, you filed this in violation of the local rules and the order of this court, and in that it's way too many pages, and you buried your argument. And buried the relief you sought. Best I can tell, and I've read it, the relief you sought seek is way down paragraphs 16, 17, and 19. Is there any relief you're seeking other than what is in paragraphs 16, 17, and 19 of your motion?
Without going through this and reading those paragraphs and wasting your time, all we're seeking is protection from a subpoena, Your Honor.
I'm sorry,
Sabre
cut out.
actually, I'm sorry.
You cut out. You said all we're seeking is protection from a subpoena, and you cut out.
Oh, my apologies. All we're seeking, Your Honor, is relief from a deposition and a subpoena. Plaintiffs' counsel and I, and also Northwood Hills Counsel, conference last Friday. Plaintiffs' counsel agreed to limit some of their discovery. We agreed to produce all of the documents for the new tenant subject to an agreed protective order. We produced all of those documents, Your Honor. In fact, we produced 361 pages of documents. For comparison, plaintiffs only produced 165 and Sabre only produced 236. So we produced a whole lot of documents, which included basically everything that the plaintiff asked for in its—
All right. What does this have to do with a subpoena served on a third party?
So, Your Honor, 192.6 allows us to, as any other person affected by a discovery request a protective order. Sabre is requesting a
Right,
protective
all
order.
right.
And we are requesting the protective order because we think that the subpoena and the deposition are harassing. It's not relevant. Am I breaking up? I hear some
Yeah.
feedback.
You are.
I'm sorry, I don't know where this feedback is coming from or how to fix it. Okay, maybe it's gone now. So we're trying to get protection for just the deposition and just the subpoena. And Your Honor, we laid out the reasons why we requested, which is it's harassing, it's not relevant information, and also the new tenant has genuine fears of the plaintiff. And so we're asking that he not be brought into this litigation.
Ms. Batiste, I'm going to ask you again, who are you representing?
Sabre.
So why are you telling me what the position of a third party is? That is not your client.
Yeah, exactly. So as the manager of the property, we have an interest in protecting the tenants in that property.
Well,
We also have an interest. I'm sorry.
Here's the court's view of this. You've claimed an invasion of personal rights. That's your paragraph 16.
Yes.
Whose personal rights are allegedly being invaded?
It's the tenant, and as the management group, we have an interest in protecting our tenants.
And as a court, my obligation is to permit full discovery except when an individual comes forth and presents either a personal claim that their rights are being violated, their privileges are being violated, or they are being asked to be overly burdened.
Okay.
If Nuve Masada wants to come to this court and object to the subpoena, they can absolutely do so.
Okay.
There's nowhere that I see that allows you as the attorney for one party to come and argue the position of a third party that their rights are being violated.
Your Honor, may I argue our position regarding the relevancy?
I understand the relevance argument. I really do understand the relevance argument. To be blunt, I've looked at this case now twice. You want my 2 cents? Your client probably has the upper hand factually on this case, but not when you're chasing rabbit trails that are. I mean, your client doesn't have the right to assert the personal rights of Nuve Masada. Your client does not have the right to make the claim on behalf of Nuve Masada that Nuve Masada is being burdened. They're a third party.
Okay.
Why do you believe you have the right to come in as an entity and assert the rights of another party? Where do you get the standing to do that?
First, we believe that the discovery is harassing, and it's intended only
To who?
to us, to Sabre.
To receive a written deposition response is harassing?
To put forth a tenant in a property managed by Sabre is for a deposition that has nothing to do with the claims and defenses of this case, for the sole purpose of trying to make our clients or Sabre's life miserable, get us to settle, is absolutely harassing. And I believe I attached an email that shows that this was the intention of the plaintiff.
I'm sorry, you cut out again really bad. Can you say that last part?
Sorry, Dina, I attached an email showing that this is the intention of the plaintiff.
Your Honor, can I say something? Whenever you're ready, I know you're following a line.
The answer is I'll let you, but why would you?
Well, at some point I need your help.
Seriously, I mean that seriously. You see where this is going.
Well, I know, but at some point I need the court's help. I mean, you've caught the gist of all this. You've already done this last Friday, Your Honor, or last week, and it's the same motion. It's the same arguments.
And unless I'm presented with a reason to grant this this amended second motion for protection from discovery here by Ms. Batiste, I'm going to deny it. If you haven't gathered that by now.
No, I've gathered that, but I'm already beyond that. I've had to do this twice, Your Honor. My client is a small business owner. I need some relief from the court. I can't be in this position every time and be buried by these companies and have to respond to this. This is a nonsense motion. It was a nonsense motion when she filed it.
You didn't have to respond to this. So I'm not going to, I hear you. I'm glad you're here, but you did not need to respond to this motion. That was your choice.
This is a pattern, Judge. I need the court to know that I'm going to have some relief at some point, because the pattern has already started with them doing this. You know, she acts like the rules don't apply to her.
All right.
She's directing you.
You know what, counsel, you're hurting your position.
I'm sorry, but what I meant to say is,
but means you're, I understand your position. I do understand your position. I don't need to hear anything more from plaintiff.
I won't say another word.
Unless you want to talk me out of ruling.
I don't. But I do want to say one thing, that the rules apply to all of us. The rules apply to all of us. She is not allowed to attach settlement communications and send them to you, Your Honor, because those are protected under 408. In the first paragraph of my email says that's protected under 408.
I saw that the very first, she filed, Ms. Batiste, you filed a motion in violation of the local rules and wasted some of the pages that you didn't even have to send me settlement communications that were expressly on the second page of that saying this is brought pursuant to Rule 408. It's protected confidential information, yet you filed it with the court. I don't understand what made you believe you could do that and how that supported your position here.
Your Honor, I filed that because I was trying to show the judge that our client is being harassed and that there's no other purpose for these discovery requests but for to harass us. And it was not filed for the purpose of or in front of a fact finder. For the purpose of fact finding, it was only for discovery protection.
All right. Do you have anything further to add?
No, Your Honor.
No, Your Honor.
The amended second motion for protection from discovery is denied.
Okay.
We've submitted an order online, Your Honor, for your consideration.
Yeah, I saw that you did.
You probably just need to strike through the attorney's fees portion, or I can submit a clean one if you'd like.
No, I'll sign that with that paragraph stricken.
Thank you, Your Honor.
I mean, and now let's go off the record.
Yes, sir.
But we're still going to be on YouTube because we're about to jump into another hearing. Ms. Batiste, you don't have standing to assert this. I mean, if your client is burdened, that's one thing. I mean, seriously, if your client, if this was requiring your client to do something that was burdensome, that's one thing. But if that third party is burdened, they have a remedy. They can hire a lawyer and come here and make the claim. This is too voluminous. That's done every day, thousands of times. Subpoenas are served on third parties. Just ask any insurance carrier or any medical provider out there. They get hundreds of subpoenas every day. Sometimes those subpoenas are voluminous. Sometimes, most of the time, in fact, they hire lawyers who actually go through and assert their rights pursuant to those. But it's not the opposing party in the litigation that asserts those rights unless the opposing party's privacy or privilege rights are being violated.
And I understand your point, Your Honor. Our point, which obviously is not is not something you agree with, is just that our client is suffering because this subpoena and the deposition requests are affecting our ability to manage the property.
Okay, well, motion's denied. So
Thank you, Your Honor.
you're welcome. And well, I'll sign the order here in a minute.
Thank you, Your Honor.
Thank you.
Thank you.
You are excused.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Ms. Rouse, we are in recess for about 14 minutes. I'm about to send you the email you and I talked about. I'm going to go on virtually off the bench, but I'm still going to be here. And you can start admitting people. I see some are waiting at least.
Okay. And I'm just forwarding, right?
Forwarding or separately emailing. I don't care how you do it. It's a PDF.
Okay. I will look for it right now.
All right.
For couple minutes.
Well, yeah, I'll be real clear. And if I'm not, I'm sorry. This is my proposed order. I'm going to start the hearing. We're going to do some whatever preliminary matters we need to do. Then I'm going to tell them that I've got a proposed order. I want them to look at it.
And that's when I'll send it.
Yeah. And then we're going to take a recess while they look at it.
Okay. Sounds like a plan. Okay, Jackie Baker. What's that? I'm on, I'm just in between hearings.
Hello, can anyone hear me?
Yes.
Hey,
Okay.
Johnny, I can hear you as well. And Brett actually just messaged me and let me know that he is going to handle the hearing from his office. So we actually don't need Morrow set up anymore.
Okay.
Sorry about that.
Yeah, it's okay, no problem. I will, I'll just disconnect this then.
Yep, that works. Thank you so much. Appreciate it.
No problem, have a good one.
Thanks, you too.
Robert, how you doing?
Well, Brett, how are you doing? Jackie, how are you? Hey, Deanna.
Deanna.
Council, good afternoon.
Good afternoon.
Your Honor.
Welcome back to the 95th District Court. Are we expecting anyone else here?
Not to my knowledge, Your Honor.
Then let me formally recall DC 20-07194.
Oops, there's somebody coming.
Yeah, take a minute, Ms. Rouse.
There you go.
Ready, Ms. Rouse?
Yes, sir.
Culinary International Inc. versus DSM Management Group Inc. This is a continuation of the hearing on the motion for temporary injunction. Is there anything else to take up on the record?
Yes, Your Honor. I've communicated with Mr. Govett. We have sent the court and would offer an affidavit of Claire Ott, who is our firm trust manager, and essentially setting forth what we advised the court on Tuesday, which was that our firm is currently holding at least $330,000 in our firm's IOLTA Texas trust account held in trust on behalf of our client, DSM Management Group, Inc., and that the funds were received via wire transfer from the operating account of DSM Management Group, Inc. And subject to any objections Mr. Govett might have, we would offer Ms. Ott's affidavit and ask that it be admitted into the record.
For record purposes, shall we refer to this as Exhibit 601, 601?
Yes, Your Honor.
Does that make sense?
Yes, Your Honor.
All right. I have a physical copy of Ms. Ott's deposition. I am putting an exhibit sticker on it as Exhibit 601. And I understand that MGI has offered 601 as an exhibit. Mr. Govett, do you have any objection to 601?
Your Honor, I don't follow the relevance, but you know, as it is, it is.
Fair enough. I question the relevance or whatever, but it doesn't hurt to add it to the record. So 601 is admitted.
Thank you.
And I should have made a reminder at the beginning. I understand there is a possibility that there will come out of this proceeding an appeal, an interlocutory appeal. And I'm going to talk to you all about that before too long. I don't know that it's going to happen, but it very well may, because the rules expressly authorize ruling on a temporary injunction to receive an interlocutory appeal. You are going to see in a minute that I'm crafting this as best I can to avoid that. But if it happens, there is one record and one record only that comes out of this proceeding, and that is the record that is maintained by Ms. Rouse. What is being streamed on YouTube and therefore could ostensibly be recorded off YouTube or downloaded off YouTube. It's not a record, and you cannot use it. And in fact, you're prohibited from using it because I have not issued an order allowing the recording of this proceeding. I know I'm being redundant. I know y'all understand that, but I feel an obligation to say it once again. All right. 601 is admitted. Is there, thank you both. I received your briefing. Thank you both. It's been reviewed. I think you're going to see in a minute that the court has reviewed the evidence. I want to say this, and some of your clients are present, and this is meant very truthfully. I applaud the legal teams from both sides. What you've done, to be blunt, is monumental. to have done in this COVID era, to have presented 100, I counted and I don't remember now, 115 exhibits, 10 testimony from 10 witnesses, and to have done so and argued it in a way that made sense to the court and presented a full picture to the court, and done so in a hearing that was basically 3 hours is a monumental task, and you should be applauded, both of you, for having done so. And I truly mean that.
Thank you, Your Honor.
Thank you. Very kind, Your Honor. Appreciate it.
You're welcome. You may get an opportunity to do some more of that in the next few months, as you're going to see here. All right. Anything else for the record?
No,
I
Your
don't believe so, Your Honor.
All right. I'm not going to hide the ball. But I've got something I would like you to, both legal teams, to do over the next 20 minutes. I have written an opinion and an order. And I'm granting the motion for temporary injunction, but it's granted contingent on Cullen Air being ready for a December trial on the entire merits. And you'll see my rationale and basically I'm going to tell you the fact that there are no live performances until April ultimately weighed in on the final element, the proof of damages. We can decide in a December trial whether or not the damages are calculable to a certain pecuniary standard or are not. And I'm envisioning a final trial of this case in December of this year. I've laid out the reasoning in the opinion, but I would like you to confer on the order. Here's what I'm proposing in the order. A 2-day trial on December 17 and 18. And you'll see it here. I'm going to have Ms. Rouse email this to you in a minute. I would like you to confer with your calendars, with your clients' calendars if need be, confer with your clients, confer with each other if you have to see if you two think you can do this. I'm proposing a December 17 and 18 trial. Each side gets 1 day's worth of trial to put on their entire case, whether they want to spend it with evidence, argument, or whatever. I also understand there may be a request for a jury trial of some aspect of it. If that happens, we're going to have to deal with how we're going to pull that off. I am currently serving on a subcommittee of the judges here to try to figure out how we can get jury trials going again. So that's a work in progress. If you ask for a jury trial, we obviously won't start on a Thursday. There's a reason why I'm picking December 17, to be real honest. I wanted to give you enough time to get ready. The following week, my reporter anticipates taking a vacation. That's Christmas week anyways. The week before that, I anticipate being at the College for New Judges. And I don't know if that's going to be remote or in Austin. I'm hoping it's in Austin. And so that really leaves that middle week, 14, 15, 16, 17, 18 to do this. And the 17th and 18th, currently there's not a thing set on the court's calendar. So it's not like I'm bumping some hearing somewhere. We could do it before the College for New Judges. We could do it in January, but I may not be judge in January, and I understand that too, because I won't know that until November. So that's how I came up with the dates. If they work for you, great. If they don't, great. Let me know what works for you when we come back in a few minutes. I'm not ordering you to mediation. I'm recommending you go to mediation. If you want to come back and ask me to put it in the order, I will. I put the beginning parts of a scheduling order in, but I'm going to let you all run the bus on when experts and everything else is to be scheduled. Y'all have obviously demonstrated you can do that quite well in even a shorter period of time. So unless you have questions of me now, let's go on recess for 20 minutes, come back. Ms. Rouse will send you the proposed order, and we can come back and discuss it.
3 o'clock, Your Honor, 3 o'clock.
If you wish, 3 o'clock is perfect.
Okay, because that's 20 minutes.
Yeah,
Okay.
very much. 3
No, I
o'clock.
appreciate it.
You're
Thank
welcome.
you. Okay,
We're in
thank you.
recess.
Okay.
Okay, I'm sending it right now. If somebody doesn't get it, if y'all can hear me, just send me an email. I think I have everybody copied.
Ms. Rouse, you there?
Here we go. Oh, whose background is that? If anybody's on here not busy, could y'all spell Yoshitomi for me real quick? I can't find it easily. Unless y'all are busy.
Give me a second, Ms. Rouse. I've got it.
Oh, I wasn't trying to bug you.
That's all right. I'm here. I was actually trying to tell you something a minute ago. All the exhibits are on your desk in the courtroom. That was the easiest place I could find to make sure that
Perfect.
these exhibits stayed together. And that's
Yes, sir. Thank you so much. Why is that not coming in? Huh.
and it's YOSHITOMI.
Okay, awesome. That's what I put, but I was like, not sure if that's right. Thank you.
You're welcome. I'll go off screen here just a minute.
Okay.
Ms. Rouse, do you have any idea who Joseph, Missy, Adelaide, and Lulu are?
That would be Joseph Yoshitomi, Your Honor.
Okay. We'll admit him back in.
I tried to do it a minute ago and it wouldn't go, but here, well, and then they disappeared. I don't know what's going on.
There we go. Well, counsel, then let's go back on the record in DC 20-07194 Culinaire versus DSM Management Group. Any comments, observations on the order, the form of the order, including the dates in the order?
Your Honor.
Yep, Your Honor, if I may. First off, on behalf of DSM Management Group, we would assert and object that the order does not satisfy Rule 683 in that it doesn't specifically define the imminent harm that Culinaire would experience and does not describe why it is irreparable. Your Honor, we would also just in response, or I guess with respect to the order, the other issues are the order sets forth a bench trial. There's currently a jury demand pending in this case. And even if Culinaire were to withdraw its jury demand, the DSM Management Group would demand a jury. Your Honor, we also believe at the hearing, we talked about the recommendation we made on the bond was $100,000. We believe that the order violates Rule 683 by not requiring a bond. And, you know, within the record, we've shown the importance of having a qualified food and beverage provider in the music hall. The other objection we'd make to the order is that in essence, at least between now and the trial, awards Culinaire the relief that they seek at a final trial, seeking, you know. And so we think that that also violates Rule 683 as well as existing precedent. And Your Honor, we would also request specific findings of fact by the court.
The court will happily issue findings of fact, but I'm going to insist that that the parties make a specific request in writing and in accordance with the rule.
Yes, we will, Your Honor.
As to Rule 683, it says every order granting an injunction and every restraining order shall set forth the reasons for its issuance, shall be specific in terms, shall describe in reasonable detail and not by reference to the complaint or other document the act or acts sought to be restrained, and is binding only upon the parties to the action, their officers, agents, servants, employees, and attorneys, and upon those persons in active concert or participation with them who receive actual notice of the order by personal service or otherwise. I think this order, especially in conjunction with the opinion that accompanies the order, absolutely meets that ground. Shall include an order setting the cause for trial on the merits with respect to the ultimate relief sought. We have done so. The court shall, Rule 684, the court shall fix the amount of security to be given by the applicant. I explain why I think clearly why I'm choosing to waive bond. If that ends up being a grounds for appeal, I'm going to set a bond, but it's going to be a pro forma bond.
And we would ask, we just to eliminate any issues, Your Honor, we would ask for a nominal pro forma bond. And we are prepared for trial in December on behalf of Culinaire.
All right.
Whether it's a jury trial or a bench trial, we are prepared for trial in December before Your Honor.
I will revise, the court will revise the order and order a $1,000 bond. All right, as to jury trial, I've heard it absolutely stated that jury will not be waived, in which case the December 17 date doesn't work.
Before you, we would like a chance to, because we're going to be trying the permanent injunction, Your Honor. I'm not sure there is an absolute right to jury trial on that. We just need to do a little research on that. I think you indicated that when we spoke on Tuesday.
Mr. Govett, we're doing a final trial of this case, and that is that we'll see in a couple weeks, based on your final pleadings, whether the only thing you're asking for is a permanent injunction or whether you're seeking breach of contract damages. I'm anticipating, you can plead this and try it however you want, but if you're going to plead for breach of contract, he's entitled to a jury on those issues, and we're going to try the whole thing.
And we're ready to. However the court wishes to try it, we will be prepared to try it that way.
You'll definitely make the court's life easier if it's only a permanent injunction. Well, my solution to the jury issue is making it be set on the jury docket for the week of December 14.
That's acceptable. Yes, that's fantastic, Your Honor. We will be ready.
Is a day of trial time sufficient for each party?
It is for us, Your Honor.
Your Honor, we would expect needing at least a week.
Well, I'm going to set it for the week of December 14, unless MGI wants to set it out to next year, in which case it's MGI that's moving it past December. I'm going to set it December 14. All right, anything else about the form of the order? Is the pleading deadline sufficient? Is or any objections to it, I guess, or proposed revisions to it?
The pleading deadline is fine for culinary, Your Honor. That's the September 18th for
Yes.
affirmative relief, September 25 for responsive pleadings.
Yes.
That's acceptable to culinary. Thank you, Your Honor.
How about MGI?
Your Honor, with respect to that provision, we would accept that.
All right,
Again, as to that provision only, Your Honor.
I understand. You're not giving up anything in this at this point. We're talking form, not substance, anyways. Y'all want me to appoint a mediator?
Yes, Your Honor. Or at the very least, require mediation. I mean, Brett and I could most certainly work to see if we can agree on someone. Perhaps the court would appoint a mediator subject to the parties being able to select their own.
Who do you have a preference on mediators, Your Honor?
I was going to suggest somebody for you, and that's former county court at law judge court number 2, King Pfeiffer. Another option was I was going to suggest Jim Jordan. I also think the world of course. Now I'm sticking all burden, I think, here is Mel Wolowitz and Charles Oliver. All of them would do an outstanding job on this.
I like Judge Pfeiffer, Your Honor. He's fine. Robert may have some.
You know, no, I was just going to say, you know, Judge Pfeiffer, perhaps Bob Genevine was another name that came to my mind.
Top
As
notch.
the court knows, former judge as well.
Okay, I'll appoint Judge Pfeiffer. Okay, very good. Anything else need? I mean, do you want me to do a full-blown scheduling order in this, or can y'all work out the other details on the scheduling order?
We should be able to work it out, Your Honor. We worked it out on the first one.
That was my read of it.
Right.
Anything further from either of you?
Nothing from the plaintiff, Your Honor. Appreciate your time. Have a fantastic weekend. Mr. Rouse as well.
Before you get Mr. Whitty?
Nothing at this point. We will, of course, submit our written request for the findings as well as follow up regarding the order. But we appreciate the court's time. We wish you and Ms. Rouse a very good holiday weekend.
Thank you. You the same. It's going to take me probably an hour to get this redone up and proofed. So it may not get online till Tuesday now, and I'll just tell you that flat out. But y'all have the semblance of what's there. So
understood. Thank you, Your Honor. Appreciate it.
Thank you.
Thank you, Your Honor.
You're excused.
Okay, I'm turning off. Thank you.